Hello, I'm Dan Flack at KC Elder Law Firm. Wanted to just give a little bit of time for people who might be showing up late. But to start with, as you all should know, I'm going to be going over the division of assets and essentially in broad terms how that works. We do planning in both Kansas and Missouri, and there's certain things with each state, differences that come up in the Medicaid rules. So just be aware, I'm not necessarily going to get into all the differences and how they work, but if you do have any questions, you should have at the bottom of your screen a little bubble link you can hit for Q&A. If you'd like to type in a question, I will try to get to it before the end of our time. And of course, if there is anything that you have question-wise after this or need anything, feel free to call into our office. Myself or anybody else here in the office is happy to try to help you. The number 913-338-5713, and you can always go to our link at kcelderlaw.com. Okay, so first thing is when it comes to the division of assets, everything starts with what we in our office call the snapshot. That is the point at which one of the spouses has been out of the home for a period of 30 days or more. That can be 10 days in a hospital and 25 days in rehab. They could even come home after that. So you may be dealing with someone, for example, who say they went to the hospital on June 20th, 2019. Then on July 3rd, 2019, they transferred to a rehab center, and then they came home on August 1st. Well, the first date for all of that was June 1st or June 20th. So in that case, the assets would be looked at as they were in June 2019. Even if that person came home after that stay in August, then finally came into a care center in January, everything would be based initially on that June date. And what they will do is they will require you to provide documentation showing all of the assets owned by the couple at that time and what their value was. Something that trips people up. I have clients sometimes who say, well, I didn't think I had to include that because it's in my name and not my husband who's in the care center. Does not matter. Medicaid looks at it as just a grand total for both of them, whether it's in his name, her name, or both. Now, there are certain exempt assets that would include the house, a vehicle, prepaid funeral plans. You need to make sure that those plans are irrevocable. It also, in both Kansas and Missouri, they exempt income producing property. However, you need to make sure that there's differences in the two states. There's a more strict requirement in Missouri than there is in Kansas. The same thing with, say, a property that's up for sale. If you've got real estate that's up for sale, it's a little bit of differences between the two states, but generally that is exempt. Another big tricky thing is in Kansas, you can run into a problem where if the house or any income producing property is in a trust, it is no longer exempt. It counts just like money in the bank, whatever it's worth. So that's something you definitely need to look out for. So the way that it works is for that June date, and hopefully you can all see this. The way I like to think of it is that all of the assets, it's like if you liquidate them down into cash and put all that cash into a bucket. And so if you did that, and let's say in June, the cash filled up the bucket to $30,000. Then what Medicaid says is they're going to take that number of what it was in June of 130, they're going to divide that in half, which is 65,000, and they'll say you can be eligible for Medicaid when you've reduced the bucket, the assets, down to that $65,000. Now, some people think, oh, well, then I just have to show that I spent $65,000. Not necessarily the case, because if this spend down is happening over a length of time, there are things that are going to change. For example, if assets in their names have gone up or down in value, investment accounts and such. Additionally, each month they're getting their income, which is maybe not that much, but it is adding to a level in the bucket. So in this example, once they're down to that $65,000, they're eligible. Now, there are a couple of things to keep in mind with that. There are maximum and minimum amounts that you have to deal with. Now, in both states, and these numbers change annually and once a year, right now, the maximum is $128,640, and the minimum is $25,728. Now, how that plays into things is, for example, if when they went in and started their stay, they were at, let's say, $30,000, and forgive the penmanship. Well, half of that is $15,000. They don't have to get all the way down to $15,000. They just need to get down to the minimum of $25,728. Now, if at the time they come in, all they've got is $15,000, they're already below the minimum, they're eligible. Now, with the maximum, that would mean that if when they came in, they had $300,000, well, half of that is $150,000. Well, they can get down to 150, but that's not enough. They need to keep going until all they've got left is $128,640, at which point they're eligible. Now, when it comes to getting the assets reduced, there's many different ways to do it. Basically, anything that they use their money on that's for either of them, the spouse, the institutionalized person, or their spouse, it's reducing the level, it counts. The only time there's an issue is if they're giving money away. If they're either buying something and they're paying more than fair value, that would be like if they said, okay, I'm going to buy my daughter's $20,000 house for $100,000. Well, that's giving your daughter $80,000. And of course, just giving the money away. If you give money away, they penalize you and you're ineligible for a length of time that depends on how much was given away. Some ways to reduce the assets that are real straightforward. The car's exempt. So maybe they've got an older car, they need to buy a newer car, need it to last them for a while because they're only going to have what's left when they go on Medicaid. Medicaid's not going to buy them a new car if it breaks down after they're on. So purchase it now while it's helping to qualify. If they've got a mortgage on the house, pay it towards the mortgage. Additionally, if they want to get improvements around the house, they need new carpet, a new roof, anything, any money, cash that's countable that they are turning around and putting into the exempt house, that's helping get them qualified. Same thing with funeral plans. If they don't have those at the time they started this, buy funeral plans. As long as you make them irrevocable, it's exempt. Then there's also tools that you can do, planning options available that can get you qualified. Okay, and I see just while we're on the topic of gifts, somebody asked that they've heard you can give $15,000 a year. That's a tax issue. The IRS has got a tax limit per year of $15,000 per person. Medicaid does not care. Medicaid penalizes gifts at $1. And I'm sorry, I should probably mention, it goes back 5 years. So when you go to apply on that question, on that application, there is a question that asks, have you transferred, sold, or given away any assets in the last 5 years? And so any gifts or transfers that were made during that time come into play, and the penalties on those gifts do not start until the person would otherwise be qualified. So even though they may have been in the care center paying for a year, the penalty didn't start when they went in the care center. It starts when they're already spent down and eligible. And at that point, the person's paying from their own money that they would have protected otherwise. Let me see if Missouri would be beneficiary for whole life ever be able to receive the money, or Medicaid always receive it. Question is, if a person has a whole life policy, and life insurance is tricky between the two states. There are exemption provisions in both states for life insurance. It's pretty complex, and I don't necessarily want to get into all that here, but they're asking about if the person who's the beneficiary on the policy will get that money. I can tell you that right now, Medicaid is not pursuing those funds. It does not mean they won't in the future. Everybody sees the news, and Medicaid, just like most things, are hurting for funds, and because of that, they're being more aggressive. They could change their policy and start trying to go after those. Question about IRA exemptions. That's different between the two states. That's a simple answer, which is in Kansas, if the at-home spouse has an IRA, it is exempt. In Missouri, all the assets count, including the at-home spouse's IRAs. Now, when it comes, as I was mentioning before, when it comes to planning, there are different things available. You can gift, I said no gifts, but if you gift funds or even your house to a disabled child, there is no penalty. Additionally, there can be ways to give your house to a child who's been providing care in the home. Again, very tricky. One thing is, there's all kinds of conditions on it, so you need to make sure you're talking to somebody who knows their stuff so they can tell you whether or not you can do it. Also, they change all the time. You want to make sure that you're talking to somebody who does this for a living and keeps up to date on the changes. And another tool that is available is something that somebody mentioned here, which is a single premium immediate annuity. You can purchase an annuity for the at-home spouse, and it can be exempt as long as it meets all of the requirements that Medicaid has on those. And there are a lot of them. Too many to go into here, but again, that's something where you want to make sure you're dealing with somebody who knows all of the latest requirements that Medicaid has for those. I often see where people will contact us and they've already purchased an annuity. I see this especially when it comes to VA benefits for a while, and hopefully it's kind of died down personally, but people will buy annuities to get VA benefits. Well, those annuities are not necessarily set up to meet the Medicaid exemptions, and it becomes a countable asset, and it can be a lot of work to fix that. Someone asks, their mom is in a long-term care facility and on Medicare, Missouri Medicaid. Saw where she can gift her stimulus check. Is that true? The stimulus checks are being treated differently than most things. First of all, the main thing is that putting them over their Medicaid limit. Now in Kansas, the person on Medicaid is limited to $2,000. In Missouri, that's $5,000. So if it didn't put them over, there is no issue. It's just money they can keep and use as they need. If it did put them over, then they will have up to a year to spend that money on themselves and get spent down. Again, they don't necessarily need to spend the whole thing, just enough to get under. And when it comes to up to a year, what they've said is you have basically until your next reinvestigation. Because when someone's on Medicaid, once a year, they do a reinvestigation to get information to make sure this person is still eligible to receive benefits, and those reinvestigations are at the anniversary date of the person's eligibility starts. So if they were eligible in April, then they'd have until April of next year to get the money down below $2,000. As far as gifting it, you can't really do any gifting when you're on Medicaid. So I am not aware of any provision that would allow that. However, the amount of the gift determines the amount of ineligibility. So if it's a small gift, small period of ineligibility, but not necessarily the way I would go with it. Now, another thing I wanted to bring up is estate recovery. Medicaid, when someone's getting benefits, are keeping track of how much they're paying out in benefits for that person. Now, they can't make any recovery on that until both spouses have passed away. At that point, they would be able to come after whatever was left in the name of the last surviving spouse. However, they can, if the couple owns a home, they can put a lien on the home. They can't kick them out. They can't, I can't think of the term right now, but they can't force the lien and say, okay, you owe us money, you have to sell your house and find another place to live. They won't do that, but if that spouse at home enters a care center and the house is empty, or if they try to sell it, at that point, even if the spouse is still alive, they can come after their share of the proceeds. It's something to watch out for. There's ways to get that lien taken off, but again, it's complicated and both states are different. And you want to make sure that you're talking that over with somebody who knows about these kinds of things. And I'll tell you that when it comes to talking things over with somebody who knows their Medicaid, feel free to call us if you have any questions. Or if you run into somebody who has questions, please send them our way. We offer free consultations. They can contact us. They can call us, 913-338-5713. They can also go to our website, kcelderlaw.com, and put in a request there. We will evaluate their situation. We can sit down with them, give them a 2-hour in-person meeting at no charge, where we will get into detail about what they're going through, what can be done, how we might be able to help them, what they can do on their own. I will tell you personally that I've been doing the Medicaid here in this office for over 20 years, and a sizable amount of my job during that time has been calling people to walk them through how they can handle this themselves. We're not going to just try to get every penny we can out of everybody that touches base with us. We want to be a resource, so don't hesitate to send anybody to us. I also, I don't know how many of you or if any of you might be working with care centers, but I work with the Kansas side. We have another coordinator that works with the Missouri side, and I know that I have relationships with most of the care centers in the area, and I get lots of times where people will call us and say, we've got this person that just came in or who's been in a while and they've got this problem, and how would Medicaid handle this? Always happy to be a resource. Always like to show off what I know. That just about covers it. If you have any questions or issues that I haven't addressed, again, feel free to contact us, and I'm happy to go over that with you. If there is, just want to make sure I haven't missed any questions here. Oh, wow, I'm sorry, I did. When on Medicare, Medicaid, does my mother need a secondary insurance? Okay. When it comes to health insurance, when Medicaid calculates how much of the care center's income has to be paid to the care center before they kick in and pay the rest, they let them keep enough income to cover the premiums for any secondary insurance they have. Because of that, it is extremely rare that it is a financial benefit to them to cancel that insurance. Now, there also can be big benefits to keeping it, one of which could be if they want to see somebody who doesn't take Medicaid, but maybe they take that secondary insurance, then they're covered. Another thing is, if they were to lose their Medicaid benefits, they've still got that secondary insurance. If I live with my child, can I pay them rent, or is it considered a gift? When it comes to rent, you want to have a rental contract in place because Medicaid does, especially anytime there's money going from a parent to a child or other family member, Medicaid looks at that very closely. So you do want to make sure you've got a good, solid type of rental agreement in place that Medicaid won't have issues with, and that the payment amounts are fair. So again, that's something you'd want to check with an attorney on. In Missouri, can they have $4,000, or has it changed to $5,000? It is now $5,000. It's $5,000 for a single person. It's $10,000 for a couple if you're trying to qualify both of them for benefits. Another one, their mother is currently in a nursing, I'll say care center, in a private room in self-paying during the spend down. Can she keep her private room after becoming Medicaid eligible? That's something that you can talk with the care center about. They, most of them, I quite frankly not found one yet that wouldn't do this arrangement, but what they will do is say, okay, you have to pay the difference between what we're getting under Medicaid and what we would receive if we had a person private pay in this private room. And then typically you can do that, which is another reason why it can be a really good idea to get with an attorney about planning, because they can typically, when somebody goes on Medicaid, they only get $62 of their income each month for anything else that comes up. That includes, when they need clothes, anything they need that's not medical. So doing planning can help protect some of their money so that maybe you're able to set it aside and then have more money to help cover those kinds of things. Then somebody asked, can they just put their assets in a trust and have them non-count? No. There are certain provisions of putting money into a trust when it's a disabled child, but those are very, very specific. However, generally though, a trust owning something, it's still owned by the people who are applying. It still counts. And then you really need to worry about, is the house in the trust when it comes to Kansas? And then somebody asks if I could explain the rationale between irrevocable trusts and revocable trusts when it comes to Medicaid. I want to say here that I'm a Medicaid coordinator and I know Medicaid. I don't want to get too into trust things. I don't want to speak incorrectly, as that's not my area. But as far as Medicaid goes, I can tell you that the pitfall with an irrevocable trust is that you can then end up with assets that you can't access that Medicaid is saying are available and countable, and keeping them from being qualified. In some cases, and we've had those, we've had to actually break those trusts, and it's not a simple process. So it's definitely something before you just throw everything into an irrevocable trust and say, there, it's not mine anymore, I need Medicaid. You want to talk with somebody who knows this kind of practice. Well, I don't see any other questions as I'm about to say goodbye, so nothing's come up. I just want to thank you all for taking the time to listen to me talk about this stuff. Hopefully I've given you some valuable information, and as I've said, I really enjoy talking about this stuff, so don't hesitate to call us if you've got questions. And again, we want to help, so if there's anybody that you run into that's dealing with this stuff, they've got somebody who just got put in a care center and maybe they think that they won't need Medicaid for years and years. It's better to have them call us now. We'll tell them, you're fine, you won't need Medicaid for years and years, and there's nothing else you need to worry about. But maybe, and here's something else I will bring up, just a small thing I'll touch on of estate planning, which is powers of attorney. It's never too soon to get a good power of attorney in place. We have at times had people come to us and there is planning we could do, but by the time they've come to us, the person has no capacity and can't change their document, and the document they have doesn't have the right language to allow us to try to do any planning for them. And in those cases, they're out of luck. So it's never too soon to contact us or anybody who is in this area and knows what they're doing and get some good advice. So with that, I'll just ask you, and one other thing, if any of you have any ideas for topics you'd like us to go over in the future, don't hesitate to send those to us. You can always send those through our website at kcelderlaw.com, and we'll see if we can't touch on those things in the future. And with that, I'll just ask you all to have a good holiday weekend and take care and be safe.